Is anyone present in the matter of? That is City of Kennesaw versus William Johnson.
There is an attorney back there with a client. I don't know. It's the same two that were here earlier.
Mhm. That's them. Yep, I'm ready to go. If they're ready to go. To have a trial. I imagine Randall's going to try to speak with them for a few more minutes, but I'm ready when they are, because at 2 o'clock, we're starting the other one back. With hopes to get that one wrapped up this afternoon.
Hopefully.
Good afternoon. Pardon?
They said you were ready for Johnson case?
Yes.
Okay. I'll leave that.
Did you let Mr. Bentley know we're ready?
I'm not sure where he is.
Okay, fair enough.
I think.
Let's see, is Mr. Wingler available? Okay, well, they'll show up here in a minute, I imagine.
Can't try without him.
Can't try it without. Yes, sir. Yeah, they're coming back at 2.
Your Honor, there's a video in question I have seen here.
Okay, that'd be fine. Just report back.
Wheels of justice never slow. Yes.
Yep.
Hey, Linda, did that video still set up to go for 1:30? It still go? Thank you.
Oh, show him?
Are you sure? Okay. She said that to you, or- Oh. It's only one of your witnesses.
That's why I understood that only one's coming back.
Take him back to the room, get him out, need to go outside.
He's gonna be the next witness, so I think we can just leave him sitting
Just leave
here.
it, okay, all right.
Yeah.
Okay, just want to make. You're gonna be the next witness, you're fine, right?
Good afternoon, everyone. This is Judge, my name is Judge Mays. This is the City of Kennesaw Municipal Court. Today is trial date. want to thank everyone for going through the screening process to come into the building this afternoon. While you're inside the building at all times, please continue to wear your mask over your nose and your mouth and maintain 6 feet of social distance to those around you. There are hand sanitizing stations available for your use throughout the building. Please feel free to use those as you see fit. We had a case called back for 1:30, which I believe are still in discussions with the solicitor and have not announced ready. Also on our 1:30 calendar is the City of Kennesaw versus Jason Stoughton. Is anyone here in that matter? Nope.
He's paid,
Oh, he did?
but he paid back in August and still goes to church. So I don't know if he was a failed appeal and then paid it,
Mhm.
but he still wanted to try.
All right, well. You're to appear. Let's see, everyone on the 2 o'clock calendar has already been addressed. Mr. Gordon pled this morning, and Ms. Smith is reset. I think that just leaves us with the City of Kennesaw versus Kevin Crawford, which is recalled for 2 o'clock. Mr. Solicitor, are you ready?
She doesn't speak any.
I'm ready to judge on Crawford.
Is Mr. Crawford and Mr. Haley here?
I've not seen this.
Yeah,
They have a few minutes.
My next witness sitting in the courtroom. That'll be my next witness.
Okay. That'll be fine.
oh, she's with her. Maybe send you to it.
I'm not sure. I should have the rest of the afternoon.
Can you print out Mr. Crawford's history with the city? So we can count how many times he's been convicted of this in the last 12 months. I think he already has 4.
So this isn't.
Oh, yeah, he's gonna need to go. Just actually holding others from sitting in right over there.
I don't know if you want me to make a motion or when you're ready, I have a motion.
One, two, three.
Those are in the last year.
2020. So you want to count that one?
No, we gotta go from November of 2020.
Okay, that was November 2020. So this is one. Two. What if it's the same day?
Yes, if it's the same day, I would put them together if it's the same day.
I'll double check.
Okay. All right, any pretrial or any other motions before we resume trial?
Yes, Your Honor. This time we move to exclude any additional witnesses other than those that were disclosed in state discovery, disclosure, certificate of disclosure, 17, 16, 21. Pursuant to the city's disclosure, at this point, that would conclude all of their witnesses. So we would move to exclude any other witnesses as not timely disclosed, and as such, we would ask the state ready to close their portion of the case.
Comments?
Judge, I think the case law would show that the remedy for the non-disclosure would be to continue the matter and not to exclude the witness from evidence. So if they wish to request a continuance on the matter, then that would be up for the court to decide. But I don't think exclusion of the witness that I was unaware of that showed up here today without a subpoena that wants to be heard on the matter. Should have his right to testify. It wasn't a deficiency on our part that we didn't notice him. Just he is here, he has relevant evidence, and he wants to participate.
Well, Mr. Haley, do you want a continuance to prepare for that witness?
Judge, I think Judge, I mean, in all respect to the city, they disclosed to their witnesses, they were preparing, and provided, their paperwork as that. We relied on that. Now we're in the middle of trial, Judge, through no fault of our own, reliance upon what the city has disclosed, and been moving forward. Still, as we stand here, we don't know who the next witnesses might be, who they are, what they might have to say or offer. Surmise. I can try to figure out, and prepare for ambushes, but that's not how I've practiced law for almost 30 years. So through no fault of our own, I appreciate that we're being offered to continue the case, but now we're in the middle of trial, and through no fault of our own, asking the court for more time. Well, today's trial, Judge, and I don't think it's fair that we be asked for more time and prejudice. But that's why we'd ask to exclude them at this point.
Anything else, sir?
Yes, Judge. If what defense counsel is intimating, the state would have to end its case 10 days prior to trial. We couldn't do any more investigating after that date. Doesn't make any sense that when you have recently discovered evidence, this gentleman just showed up today. It's the first time I've ever spoken with him. It's the first contact we've had with him, as far as I know. And to say that we can't use that evidence that's newly discovered in the case is not what the law says. So, witnesses I know that I'm going to use, I have disclosed. And the continuance can be judged for him to go back and talk to the witness now. He wants to do and see if he really needs a continuance. He's the complainant on for the June 15, 2021 case. So I would suggest that we ask Mr. Haley if he wants to talk to him for 10 minutes and see why he can't be hired for this witness.
May I respond, Judge?
Please.
The implication that somehow I've done something wrong here. There's a process. It's called criminal law procedure. You disclose a witness list. You disclose that information prior to trial. You do it by a list of a name, address, contact information if you have it, or you make them available. That wasn't done, Judge. It's not my job to do the prosecutor's job. My job is to protect Mr. Crawford. So respectfully, if there's a suggestion that somehow I'm supposed to cure the state's defect, it's not my job, Your Honor. That's all I have to say, Judge. I will do whatever you tell me to do, Judge.
All right. Well, I find that the motion by Mr. Haley is compelling, and in this instance, I'm going to grant it, and we're going to move forward with the witnesses as they have been disclosed. And Mr. Winkler, I believe your other witnesses may have left.
Yes, sir. The other, I excuse the other two witnesses.
No, the two, they just got up and left. And I think they left you a note. All right, so the city rest.
Your Honor, at this time, we make a motion for directed verdict of acquittal. At this juncture, there's no conflict in the evidence that's been presented. And I think if we work through each of the citations, if you will, the ordinances that in reference to the first being in a, I guess, chronological order, Judge, we have the case that was issued, I believe it's the one that ends in 1311 with the 522 date. This one. Just make sure. This citation alleges the code section 1878. Now, at any point, the state had the opportunity to amend, to give us some definition of what they were moving on under the code section. So when you go to 1878, Judge, standard for sound control, and go through several areas that which has been submitted and stipulated to it. And it gives several definitions. And then it breaks it down even further. However, the reliance that we're asked to do is based upon, as it reads in the, and was testified, was amplified sound. But there's nothing specifically related to in the code section in order for us to move forward on and to further define. You heard in the testimony that there were no devices used to determine what that level was. And I imagine the city's going to say, well, they're not required to under the ordinance. But it's never further defined. So what are you supposed to do as the trier of fact in making a determination of whether there's a violation or not? So you have to rely on looking all the way through this code section and making a determination of one, what part of the code section are you going to apply? We have the whole code section. Well, that Mr. Crawford and any citizen in the city shouldn't have to rely just upon a generalized code violation, because it doesn't give him warning. And then it allows the officer to arbitrarily apply it, to go ahead and on their own whim and judgment. But that's not their job, Judge. That's your job. So then you're having to rely upon them. So as it relates to 1311, the generalized violation isn't specific enough. It doesn't provide guidance to this court, and it doesn't allow you to make that determination whether there was a violation, because there's no definitions in there, Judge, that you can rely on making that determination. So I'd ask for you to grant our motion and acquit as it relates to 1311. If you want to reserve until you make the other motion, that's fine.
Whichever you'd prefer.
You can make that call if you want to make a decision on that motion or not, Judge.
Well, let me hear the rest of your argument.
Yes, Your Honor. So as it relates to the second, which would be, I make another motion directed acquittal as it relates to the second violation, which would be, was I believe the June 15th date, Judge. That one cites all right, so June 15th is the 0785, Your Honor. So that one's a little more interesting. So the evidence that had shown on that was based upon the violation of 1878 4-E, which when you are now were directed, okay? So that one's telling us that in addition to being a violation of the section, E says boom boxes or other similar devices should not be operated in a public place or on a public right of way. You heard no evidence or testimony, none, that Mr. Crawford was doing so. Albeit it was his home, albeit it was music being played, albeit there was testimony as far as distances and times. At no time was there any evidence or testimony presented that he was doing so in a manner or fashion through the use of a boom box or other similar device. If anything, it wasn't. It was music being played through a speaker on his own property at that address. The city was specific. Each time, 2540 Ridgecrest Drive. So the state's failed at that, and I'd ask for you to grant our motion. Now, as it relates to the third, which would be June 20th, Your Honor. Again, that's the 17, I'm sorry, I keep saying 17 and I apologize. 1878E, which again is that same subsection. And again, we have the testimony that apparently it was loud and that they could hear it from a particular distance. That's not what the code requires, Your Honor. It requires it be a boom box or other device for purposes that's being played. I'm sure you're looking at the code section as well, Judge. Boom box or other similar device. None of the evidence has established that. Zero. Each time, again, specifically testified to as the address of 2540 Ridgecrest Drive. we'd ask you to grant verdict of acquittal in reference to that. Now, the last case, Your Honor, is, man, oh man, I'm sorry, is the August date. Now, that case is was the testimony that it was an amplified and that it was at a certain distance. However, there's been no testimony of that case was measured, it was the officer's opinion, and that again, I'm just trying to get the exact citation. It was used in the there we go. Sorry about that. It was under the last ones. That was, again, 18-78, a generalized violation. Standard for sound control. So there's nothing in the narrative or the description or the testimony that narrows it down to where actually Mr. Crawford had violated. That's why the code section sets up the different standards. Utilize those standards and the city would have been able to prosecute this case. They failed to do that, Judge. They failed to establish the volume that was in violation. They failed to establish a manner that was in violation. And they failed to establish that Mr. Crawford was the individual responsible for that. Granted, there was music being played. There were certain testimony that you heard. However, it doesn't rise to the level that the city has alleged with specificity that would be a violation of the code sections 1878. Thank you, Judge.
That's the first motion on 2105-1311. Sounds like defense counsel is attempting to make the merge of the accusation in that case. The merge are required to be in writing. He waived the objection to the charging citation by going forward with the trial today. I would ask you to deny the motion on that ground. Further, 1878 does put on notice of what they're in violation of. And in the narrative section, it gives them even more definition that they were using amplified sound at a distance of more than 25 feet away, which zeroes in on the narrative section itself. And in his discovery, he also received a copy of the police report, which gave him more details about what he was charged with. The charging document is sufficient. There's no requirement for specific code sections, subsections to be listed there in order for the charging document to be valid. Second one, second motion on 2106-075. This would be mostly made regarding the fact that he's alleging the device was not a boombox or similar device. Under 1878-81, the definition of boombox, and I'm reading from this ordinance, boombox means any self-contained portable handheld music or sound amplification or reproduction equipment capable of emitting sound. He admits that it's coming from a speaker. It's a sound amplification device. It was coming from a speaker. It's a similar device. That argument has no merit whatsoever. He made the same objection in 2106, 1046, and I will ask the judge. I'll make the same argument that I just made on the previous motion in regards to that. And lastly, On the issue of measurement, lay individuals can testify as to measurements and distances and things of that nature. There's no requirement whatsoever in the statute that we use a LiDAR or a tape measure, or as in a zoning ordinance, we don't have to produce a plat of the property and show the distance of 25 feet. Every single witness who testified that it was in excess of the distance required. Every single one. One of them used LiDAR to make the measurement. One testified that he has special knowledge when it pertains to measuring distance because of his prior military experience. So the measurement argument is just a red herring, and there's no requirement other than the testimony of the individuals regarding the distance. Now, further, if you get into this argument about audible, we did use something to measure the number of decibels. Well, going back to the ordinance itself, 1878, A1, noise is any sound, which is noise or disturbance. We got that here. We got 4 people that called, complained to the police. The police got there, heard what they were complaining about, and issued citations. It also defines noise disturbance. Noise disturbance is any sound that, under subsection B, disturbs a reasonable person of noise sensitivity. That's all we have to prove. We proved it. So that is a species argument, and I ask that you have it.
And in considering both, at this time, I'm going to deny the motions. And that would be your case, Mr. Haley.
Yes, Your Honor.
Do you have a list of all these previous?
Judge, at this time, we call John Weller.
Right. Mr. Waller, please. Page of them. I've got it.
Okay.
Should I swear?
Please do.
Mr. Waller, would you raise your right hand? You solemnly swear affirm the testimony you give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Could you state your name for the record, please, and where you reside?
John Waller, and I reside at 2284 Lakewood Drive, Kennesaw, Georgia.
All right. And do you know, are you familiar with Mr. Crawford?
Yes, sir.
And how do you know him?
I've seen him and met him over the years on Ridgecrest because I come down that road every day. I've talked to him several times, and we've become friends. I've talked to him several times and see him all the time.
All right. So about how you said you drive down that, so about how far is that from your residence to Mr. Crawford's address at 2540 Ridge?
It would be less than a mile, I think.
All right. So over the years, you've come to know Mr. Crawford?
Yes, sir.
Okay, all right. And have there been times when you stopped at his residence, and, I guess, chatted or conversed with him?
Lots of times.
All right. Have there been times when you've heard music playing?
I've heard it when I go down in his yard. I've never heard it out at the road when I'm parked at the road.
All right. Now, let me direct your attention to, I believe, June 15th of this year of 2021. Do you have a recollection of an incident when you either came to that address or were called to that address?
That's the day that on June the 15th, is the day that I had, like I said, I go down that road probably 6 times a day plus. And I saw the police, I seen Kevin, I stopped to find out it was Kevin. I got out to see what was going on. They were talking about music. He's talking about he's getting citation for music. I didn't hear no music. And so then we talked later. We were still talking, and I guess the police and everybody left. And that's when the individual, Jeff Wells, had charged the vehicle threatening him, and he had called the police back to get the criminal trespassing served, but Officer Hale and Adrian Barton refused to do that for him. And that's about all I remember about that day, other than I didn't hear no music.
Yes, sir. So when you arrived on scene, again, you didn't hear music playing or anything at that time.
No, sir.
However, in the past, when you have heard music, it was only when you came onto his property.
Right. If I walk down the driveway or if I walk around the backside of the house where the speaker is, you can hear music in the yard.
So on June 15th, that's when Mr. Crawford had attempted to make a report in reference, I guess, to his neighbor, Mr. Wells.
Right.
And then because of some allegation that transpired between the two of them, and then the officer wouldn't serve a trespass on Mr. Wells?
Yes.
All right, and you were present for that?
I was present for every bit of it.
All right. Now, if I can direct your attention to August 30th of this year, did there come a time when you were either called or responded to the property on Rich?
Yes. I received a phone call from a police officer who asked me if I was at home, said they were at my home because there was a box on the front of my house with wires in it, and they didn't know if it was a bomb or what it was. I said, you're in the.
Mr. Haley?
Whatever the box is, it's what he's testifying to is he responded to. The officer told him to do whatever it was. I mean, he's just responding to what happened, Judge.
Well, I don't see the relevance yet, but I'll let you keep going.
You can continue.
I looked at my door, there's no box or nothing like that on my house. So I realized that they were calling about him.
If I could just his state of mind and his, act in response to the officer's call, Judge, I think he's allowed to testify what he did in response and why he responded the way he did.
I didn't think there was an objection, so.
Okay, all right, go ahead. that's all.
So anyway, there wasn't no box or nothing like that at my house. So I got in my vehicle, drove down to his house, pulled into the driveway. They were walking under the porch, 3 officers. I didn't hear no music then. He came outside and they started talking, and then they cited him for the music. And I never heard no music. Didn't hear no music. It was pouring down rain very hard. And from the time I got there, when the officers were walking down the driveway, I never heard music.
Yes, sir. All right. I believe that's all that I have, Mr. Waller, Your Honor.
Cross? Can this witness be excused?
Yes, Your Honor.
All right, Mr.
Can I
Willis.
take a seat in the courtroom now?
Yes, sir, you may. Thank you so much. And call your next witness.
More witnesses, Your Honor. At this point, we rest.
All right. Then with the city having rested, or is there any rebuttal?
No, Your Honor.
All right, with the city having rested and defense having rested, evidence is hereby closed. We'll go ahead and move forward with closing arguments.
Thank you, Your Honor.
Your Honor, section 18-78A1 defines noise disturbance as any sound that disturbs a reasonable person's normal sensitivities. It also defines noise under that section as any sound which annoys or disturbs you. Section 1878A4E states that boomboxes or any similar device shall not be operated in place or public right of way, which in such a manner as to be plainly audible at a distance of 50 feet in each direction from the operator between the hours of 8 a.m. and 10 p.m. between the hours of 10 p.m. and 8 a.m. Such equipment shall not be operated in such a manner that is plainly audible at a distance of 25 feet in any direction. Section 18-78A4F, which in the alternative would also apply to the first charge 2105-1311. No amplified sound shall be permitted after 11 p.m. on Saturday, which would be a violation. On May 22nd of 2021. As I previously said, boombox means any self-contained portable handheld music or sound amplification or reproduction equipment capable of emitting sound. Reproduction equipment capable of emitting sound. So, Judge, in this case, we clearly have the evidence that shows that officer on the first case, 2105-1311, Officer Horton and Owens arrived on May 22nd, 2021 at 11 p.m. at the defendant's residence, which is in the city, which is in the city limits of the city of Kennesaw. They both testified that the noise, which is what it is, noise was audible in excess of 25 feet, which is all that is required under the statute. On case number 2106-0785, Officer Burns and Sergeant Bobo each testified that they arrived at the residence on June 15, 2021 at 4:37 p.m. And they testified that LiDAR was used to measure the distance, and the distance was in excess of 100 feet, which is far exceeds the amount required in the statute. On third case, 2106-1046, Officer Owens and Horton each testified that they arrived at the residence on June 20th at approximately 1:30 and the noise could be heard immediately from the residence from a distance of greater than 25 feet. All of these and the last case, 2108-1835, Officer Crum testified that on August 31st, 2021, approximately 10:40 a.m., he received a call and arrived at the residence on the noise complaint, and that he could hear the music, the noise from over 3 houses down, and he estimated that to be well over 100 feet from the location. Now, each of these officers testified that they could hear the music from the street. And there's been a little discussion about this subsection 4E, because it contains the words operating in public place. Now, this section does not mean governmental locations. As soon as that noise penetrated the boundaries of his yard, it is being broadcast in public. It is in the public right of way. It is going to other people's yards and houses. And these people are calling in complaints to the city of Kennesaw, begging us to help them and relieve them of this nuisance. When this is a reference to public place, it's not a restriction on governmental facilities. A restriction to government-owned properties. That term is specifically defined as, under that ordinance, as public space property category. Is any real property or structures thereon that is owned, leased, or controlled by a government entity? This violation does not have to be on public property. It becomes public when it's broadcast beyond the borders of his residence. It becomes public. People know about it. It's not private anymore. It's public. It's a public place. Everybody can walk in the street. That's public. This is not like a nuisance where there's a piece of equipment sitting on somebody's property that, even though it can be seen, it is not emitting something onto other properties. It's not like a noxious, it's like a noxious odor that is coming into somebody else's property and causing a nuisance. So the ordinance is not referring to this has to be in a government location or the ordinance to be valid. It's clear that when this noise reaches the street, it is being broadcast to the public. It's in a public area, and the city has got, the citizens are begging the city to do something to stop this, and we need to do that today. So, Judge, on On 8/10/2021, you sentenced Mr. Crawford on a third offense within a 12-month period with a fine of 250 plus surcharges pursuant to section 18-78. There were two cases, and you sentenced them both as if they were a third offense, giving him a break on that day.
I apologize. I didn't mean, could you just repeat the dates again?
I would ask you to find a violation of section 1878, A4E or A4F on the first count. On case number 1, the city is requesting a sentence of $500 fine plus surcharges as a fourth offense pursuant to 18-78A3 subsection 4, and a period of 6 months probation. We further request the court issue an order pursuant to 18-78A8B requiring immediate abatement and removal of any source of sound in violation of 1878. And such abatement shall continue for the 6-month probationary period or face of probation revocation or charge of contempt of the court's order. On the second case, we ask that you find a violation of section 1878. On case number 2, the city is requesting a sentence of $1,000 fine plus surcharges as a fifth offense pursuant to section 1878, and a period of 6 months probation running consecutive to case number 1. We further request that court issue an order pursuant to 1878 AB requiring immediate abatement and removal of the source of sound in violation of section 1878, and such abatement continuing for the 6-month period, probationary period, or face a probation revocation or charge of contempt of the court's order. On case number 3, the city is requesting a sentence of $1,000 fine plus surcharges as a fifth or subsequent offense pursuant to 18-78A835, and a period of 6 months probation from consecutive to case number 2. We further request that the court issue an order pursuant to 1878 section 8B requiring immediate abatement and removal of any source of sound in violation of section 1878. Such abatement continues for the 6-month probationary period or face a period of revocation or charge of contempt of the court's order. On the fourth case, we ask the city is requesting a sentence of $1,000 fine plus surcharges as a fifth or subsequent offense pursuant to 1878 8A3B, and a period of 6 months probation or consecutive to case 3. We further request that the court issue an order pursuant to 1878 8B requiring immediate abatement and removal of any source of sound in violation of section 18-78. And such abatement continuing for a 6-month probationary period or face of probation revocation or charge of contempt of the court's order. Judge, that would mean a total fine on all 4 cases would be $3,500 plus statutory surcharges. 4 6-month probationary periods running consecutive for a total of 24 months, during which time Mr. Crawford shall not transmit any sound from any device or location in violation of section 1878 or the 24-month period. Also, Judge, there is a failure to appear on case number 2108-1835, where Mr.
Judge, I'm going to object to this. It's unfortunately not in evidence. It wasn't established. The case is rested. State is rested, and they haven't asked to reopen in reference to that.
Judge, I just assert that the record is the evidence on that case, even scored on.
Again, Judge, I would object to anything at this juncture in reference to a failure to appear.
Yeah, I sustain that objection. I don't believe there's anything in evidence about a failure to appear. Okay. Anything else? Okay, Mr. Haley?
Judge, let me take it this way. In reference to the second and third cases, the ones ending in 0785 and 1046. Similar code section, similar from our perspective, lack of evidence and lack of testimony. However, the city is trying to establish that, I can't believe we're talking about boom boxes in 2021, but anyway. Definitions are important, Your Honor. The code section has definitions. So, and definitions have words. So again, looking at what a boombox means, literally I'm reading, boombox means any self-contained, comma, portable, comma, handheld music or sound amplification reproduction equipment, modifying handheld, Your Honor. So, again, I apologize for the argument, but there's been no testimony that the equipment it supposedly was producing this music was a boombox. So Anyway, not to get bogged down in minutia, but words matter, Judge, and words matter to Mr. Crawford. So in order for the state to rely upon that particular code section that starts off as an E, 4E, boom boxes, or similar devices, this doesn't fall within that. But more importantly, the city has tried to bootstrap in public place or public right of way. Clearly, there's been no testimony. The city is asking you to add language to the ordinance that says if it's heard, not operated, but heard. There's been no testimony or evidence that Mr. Crawford has done opposite of that. It's always been on his property or within his property, Judge. Mr. Crawford's not responsible for the city's reliance upon the Muni Code, which is, in this case, poorly drafted, doesn't give guidance, allows for capricious and arbitrary enforcement. And that's what's happened. You, as the trier of fact, shouldn't have to rely upon that. You should have clear, concise information and reliance. It's not the judge's fault. I suppose needs to be redrafted, and the city's attorney should do that to be clear and to give guidance. I'm not saying that people aren't annoyed by the music. That's not what it says. You heard testimony from Mr. Weller that said he wasn't annoyed by it. So you've got a conflict right there, Judge. One person's junk is another person's treasure. So in reference to those, Your Honor, it's not a question of if it's annoying or that it's heard somewhere. That's not in the section. It says being operated on, not projected. Put that in the code section. I've had other ordinance cases with the city and they modified and changed their code because of what we presented to the court, that it's not in the code, it's an improper enforcement. Redraft it, add language, be more clear. In reference to 1878, which is case number ending in 1311 and 1835. The reliance upon the general section of the code doesn't give the court, again, any guidance as a trier of fact. It doesn't give Mr. Crawford any guidance of what he should or shouldn't do, other than I'm relying upon the decibel limits. That's the very first part of the ordinance section. Talks about under B, what those levels are, Judge. So our reliance upon our defense, which we're entitled to, says that the state hasn't produced any levels that he's in violation of. That's a threshold. So again, not through the court's fault or Mr. Crawford's fault, but the code section needs to be redrafted and redefined and specified what is improper. Not the fact that someone doesn't like music, but give everyone parameters, Judge. So we would ask that obviously the state hasn't proven their burden and that you find in reference to 1311, they haven't carried the burden. 0785, 1046, and 1835 that as well, we'd ask for you to find Mr. Crawford not guilty.
Well, first, I want to thank everyone for their time, efforts, and diligent arguments in this matter. And I appreciate everyone's professionalism and knowledge of the law. Everyone's given me lots of interesting and good arguments to think about and to consider in making a decision in this case. And while those arguments were being made, I was doing just that. After reviewing the evidence presented at trial, the testimony of the witnesses for the city and for the defendant, and the review of the law and precedent legal cases as prepared and argued by both parties, I hereby find as follows. I'm going to take these a little bit out of the chronological order. And I think it will make sense why. On the citation for failure to appear, I find the defendant, Kevin Crawford, not guilty. I believe that the state has failed, or the city rather, has failed to carry their burden of proof on that charge. With regards to case number that ends in 1311, violation of the city ordinance 17-78. Sure, I'm stating the right one. Yes. It's a general violation of that ordinance. I believe this is exactly the type of situation that this ordinance is intended to address, and I find the defendant guilty. I believe that the city has proven their case beyond a reasonable doubt on that matter. With regards to the case that ends in 1835, also charged generally with violation of section 18-78. I find that the city has carried its burden of proof of proving guilt beyond a reasonable doubt, and the defendant is found to be guilty of that offense. Next, that brings us to a case ending in 0785. This is one of the indications where violation is specifically stated to be 1878. I believe that's 4E. On this particular case, I find that the city has not carried its burden of proof in proving guilt beyond a reasonable doubt. Therefore, the defendant's found not guilty on that charge. Citation that ends in 1046 also specifically charges violation of section 4E of 1878. I find that the city has not carried its burden of proof in proving guilt beyond a reasonable doubt, and therefore Mr. Crawford is found not guilty. All right. So where that leaves us is two cases that he has been proved guilty on. And upon reflection of those charges, upon which finding of guilt has been entered, and a review of the sentencing guidelines and any maximum or minimum sentence that are required by local ordinance, I set the sentence as follows. First, in reviewing the ordinance itself, 18-78, section 8(3) indicates very particularly that if the municipal court finds that this chapter has been violated, the offender cited shall be punished as follows. First offense within a 12-month period is a warning. Second offense within a 12-month period is a warning. Third offense within a 12-month period is a fine of $250 plus statutory charges. Fourth offense within a 12-month period is a fine of $500 plus statutory charges. Fifth offense and each offense thereafter within a 12-month period is a fine of $1,000 plus statutory surcharges. In addition to issuing a fine as provided or in lieu thereof, the municipal court judge may issue an order requiring immediate abatement of any sound source alleged to be in violation of this section. Failure to abate such noise as ordered may result in a charge for contempt of court. Now, previously, in the last 12 months, Mr. Crawford has been convicted on 3 separate occasions already of this particular offense. So here are 2 more. They are numbers 4 and 5. Pursuant to the sentencing guidelines in the ordinance, that would be a fine for 4, $500 plus surcharges. And for the 5th, $1,000 plus surcharges. And as the statute allows, I am also going to enter an order requiring immediate abatement of any sound source alleged to be in violation of this section. That means speakers that would be causing music to travel past his property lines as has been shown. Violation of that abatement order would be considered an additional charge of contempt of court. That would be the order of the court.
Judge,
if I-
just clarify, is he paying this fines and standard?
Well, according to the statute, it is an immediate fine payable in stanter.
May I just ask for clarification, the prior offenses, I'm not aware of those, Judge, so
Sure,
do you, are there disposition sheets?
I do, right here. The first was on May the 11th of 2021, a finding of guilty. Second was on this was actually the first, March the 3rd, or March the 9th, 2021, finding of guilty. Then on August the 10th, 2021, a finding of guilty. So that was 1, 2, and 3. That was warning, warning, and third.
Okay.
And so this is 4, 5.
On any of those, my understanding is you might have had paid monies or something on some of those before, or had fines.
There were some other charges as well.
Alright.
That I believe there were too fast for conditions, improper use of signal lights, parking violation. There were other charges.
But
I don't believe they went to trial, but I believe there were other.
ordinance violations, the prior ones, I mean, noise violations, Judge?
Well, there were noise violations even before that. I'm just looking at the last 12 months. When he was sentenced back in March initially,
Right.
we looked back to March of the year before.
Oh, no, I understand, but
This has been an ongoing issue.
I'm aware, yeah.
So I only started the count at 1 year ago.
Correct. And so I guess,
And I'm ignoring those that are previous to it. If you'd like for me to count them all, I can increase the fine to your client, but I don't think that's the intent of the
no,
ordinance.
that's not what my intent of my question. So I understand my pea brain. So the 3 prior incidents that you cited in your sentence were prior ordinance, noise ordinance. Okay,
Yes,
that's all.
the exact same ordinance,
Thank you.
exact same issue, exact same testimony in the exact same case.
Yes, Your Honor. Yes, Your Honor.
And Mr. Crawford, I like Mr. Crawford. Mr. Crawford has come to court always with a smile on his face. He's been very friendly and amenable and has worked his way through the process. I believe he has a wonderful spirit. However, this has got to stop. Powers that be even agree with me. So we've got to make this stop. I don't know if this is a feud in the neighborhood. I don't know what's going on here, but it needs to stop. Mr. Crawford, if you continue this behavior, it's going to continually become more difficult and more expensive. I don't want that for you. Mr. Haley doesn't want that for you. Mr. Wingler doesn't want that for you, nor do the fine officers of the Kennesaw Police Department really want that for you. So take this moment to kind of think about this and how you wish to move forward. Now, I'm ordering you not to do this anymore, okay? And Mr. Haley will explain that to you of what an order of abatement means. And I'll prepare that order, and of course, you'll have a copy of it. But I just wanted to say that above and beyond. And I certainly do appreciate everyone's testimony. Mr. Waller, thank you for being here. You've taken a greater part of your day to be here as well. That does not go unnoticed, and I appreciate that. And Mr. Haley, you've done a tremendous job for your client. Mr. Wingler, great job for the city. Okay, that'll be the end of this case. I wish everyone the best of luck. Yes, please. Uh-huh. Yep, and then 1,000 plus surcharges. Okay. I have, and no one's been here. Those are failures to appear. Yeah. Okay, fantastic.
Thank you, sir. You keep dancing, all right? It's hard to do that when you tell me to turn my music on.
I'm gonna discuss Bluetooth headphones with you. Yes, Judge. Before I come to them, we do that right now, Judge.
Thank you for your patience today. I really appreciate it. I'm sorry. We go ahead and set up. Fun stuff, right? Yes.
Had some fun.
Nice to try.
Was this a client or this? Oh, okay.
It looks so nice, you know.
Tell you. I like that jacket. Oh, he was sharp.
He's not leaving. Oh, I told him to wait, I'll talk to him outside.
Yes, sir.
Counselor. Mr. Bennett. Is there takedown or is it recorded in this court? I think they were. It's supposed to be recorded. Yeah. Oh. Good. Kyle's right there. There you are. Obviously, I'm not gonna use that as a separate citizen. Say that again? I'm not gonna use that as a separate citizen. Citizen. Unless he brings up his. Understood. Okay. I mean, here's the issue.
Nothing patriotic, gospel, they don't like it all.
This is not.
This is the William Johnson charge violation of word that's 107 of the Constitution. Are there any trial orders, motions to address?
I do not. None, Your Honor.
Make that go away. Oopsie, there we are. All right, then in that case, Mr. Bentley, would you like to make an opening statement?
That's on a very short. Mr. Johnson basically. That's on. Parking lot, from the public, basically, line is there, it's clear. It's under the- That John.
All right, opening.
Your Honor, it's our position that Mr. Johnson did not violate section 6107. Section 6107 has two issues with the statute. The first is the statute requires that the intoxication occur on public property. And this case hinges on the distinction in the code between public place and public property, which is found in section 1-2 of the code. A restaurant such as Hooters, where this incident occurred, is a public place. That is, it's a place that is open to the public. It's a defined term, specifically includes restaurants. However, it is not public property as defined in the code, which is also a defined term in the code, which specifically limits the term public property to government property. Because this alleged intoxication took place at a public place and not on public property. This is not accountability under the statute. We believe that all the evidence be that the intoxication is alleged occurred in a public place, but not on public property. So I guess.
It's all right.
In any event, section 6-1, which applies to intoxication ordinances or alcohol-related ordinances, does not include a definition of public property or public place. And so under the code, section 1-2, you have to use the definitions found in 1-2 for all sections of the code unless they're otherwise defined in a particular subsection. They are not in this case. Term public place, defined in section 1-2, shall mean any place, including but not limited to buildings or conveyances which the public has or is permitted to have access, including restaurants, soda fountains, hotel dining rooms, lobbies and quarters of hotels, in any highway, street, lane, park, or place of public resort or amusement. Restaurants specifically included, and certainly the figures would fall in that category. Public property, on the other hand, of the statute, Your Honor, means any land or lands controlled by, operated by, or owned by the city, any county of the state, any municipality of the state, the United States of America, or any subdivision of any of them. That's the distinction under the statute, which requires acquittal in this case. The second statutory issue in this case, Your Honor.
Well, I'm with you. I'm just looking at the ordinance.
Yes, sir. So the second issue in the case, Your Honor, is the definition of word intoxicated, which in fact is not defined at all anywhere in the statute. Because that term is not defined, Your Honor, it's our position that is unconstitutionally vague. It leaves it arbitrarily up to the officer to determine what in fact is intoxication. Is it 1 beer? Is it 5 beers? Is it 2 beers? And the officer will testify, and look, Mr. Johnson had been at Hooters that night. You'll see the video. It's equally parts obnoxious and boorish. I mean, that's what it is. Okay? He was behaving badly that night. There's no question about it. But the fact of the matter is, Your Honor, it's not up to the officer, and a statute can't be constitutional. It leaves it up to the officer's discretion as to what constitutes a violation of law. The public, who's a member of the public about to be charged, has to be able to understand what it is that's illegal in the statute. And so those are our two arguments. We believe that the first is incontrovertible. I mean, it just, you look at the definitions, this isn't government property, it's a public place, it's not public property. The second, Your Honor, we believe raises an important constitutional issue, and we believe that Mr. Johnson and everyone else has a right to understand what conduct is allowed or not.
So you're saying his argument is that he didn't know what behavior we're going to see was not legal.
The argument is that no member of the public could know what behavior would be and would not be illegal. Unconstitutionally, that is all true.
I see. Okay.
And what happened in this case, Your Honor, there's no blood alcohol level, there's no particular level of intoxication. Officers didn't like it because of the way it's talked to it. And look, you'll see the video, it's not pleasant. But it's not up to the officer to decide based on whether someone's a good drug or a bad drug. There has to be some specificity that allows a member of the public to understand what is the limit of it. That's why with regard to, for example, driving statutes, it's not up to the officer to determine whether someone's driving while intoxicated. There's a specific blood alcohol level. The same thing would apply in this case, Your Honor. The public have the right to understand what's legal and what's illegal.
All right. Thank you. Go ahead and call your first witness. Yes, please.
I do.
Please state your name.
Brooklyn Owens, the city of Kennesaw. 1 year. Yes, sir. Yes, sir. Yes, sir. I came in contact with him at Hooters. Yes, sir. He's right there with the dark jacket. I came in contact with him at Hooters in the parking lot. The parking lot, it can fit 20 to 30 vehicles in it. You can see it from the roadway as you're driving past Hooters. You can see it from Roberts Road and also Old 41. Yes, sir. Yes, sir. When you drive by, you see multiple vehicles from people who live in the city of Kennesaw, live outside of the city of Kennesaw, eating there. Yes, sir. When I arrived on the scene, I was actually on the backside of the business, and one of the people who went to Hooters and was eating there had drove by, and he stopped and he said, "Hey, there's a guy over here. He's yelling at the Hooters employees and yelling at people inside the restaurant." So that's whenever I made contact with Mr. Johnson over here. And I asked him to come speak to me. He immediately started walking away. He was unsteady on his feet, kind of stammering away from me. Once I was able to get his attention and have him come speak to me, I asked him to come and step out of the parking lot, away from all the vehicles near the grassy area of the parking lot, just so he was not in the way of any vehicles, no way, shape, or form of him getting hurt in any way. So once we came over to the grass, I started asking for his identification. He started yelling at me and saying things like, "Why don't you go do your job and go make sure that the illegals don't come over the border," and things like that, using profanity at me, yelling at me, getting in my face. He had his fist balled up in one hand as he was yelling at me, and he was pointing his finger as if he was trying to intimidate me as he was yelling at me. I continued to ask for his driver's license. He continued to tell me that he didn't need one to vote, and I continued to ask for his driver's license again. Once I determined that he was not going to give me his driver's license, that's whenever I asked for his name. I'm not certain as to what name he gave me, but it was not the name that he goes by, the name that's on his driver's license. During that time, I was still trying to get his name, still trying to get him to relax and calm down just to be able to talk to me. He's still yelling over me, talking over me, screaming profanity to where people on the roadway could possibly hear him, people in the parking lot could possibly hear him. And then that's whenever my backup officer arrived on scene and we took him into custody. Yes, sir. I've actually done standardized field sobriety training. So during that training, we go through what's considered like the scientific tests that we go by, but we also have other clues that can show us intoxication, whether that be slurred speech, the odor of alcohol coming off their person and their breath, whether that be glassy and watery eyes, being unsteady on their feet and things like that, which are all things that I saw on Mr. Johnson whenever I spoke to him. So Officer Johnson wrote the report, and he said that he could smell the odor of alcohol, which I could also smell the odor of alcohol. So immediately when I walked up to him, I could smell the odor. I wasn't necessarily sure exactly what type of alcohol it was, but I knew the odor of alcohol whenever I smelled it. The more he talked to me, the heavier it became, the more prominent that I could smell it off of his breath, and I knew that it was coming solely from him, because he was the only person that I was talking to. There was no one else around me to where I could think, oh, it could possibly coming off of this person, off of this person. I knew it was coming from him. Public intoxication. Yes, sir. Yes, sir. Yes, sir.
Okay, admitted, no objection. It's just certified copy of the ordinance.
Officer Johnson wrote the citation? Yes. Okay. Yes, sir, I do. It's my body cam footage, and I believe it's also Officer Johnson's body cam footage. Yes, sir. Yes, sir.
Okay, all righty. So stipulated. Play the first one. All right. Let's see if we can get this. It should be able to come up on all the screens, so everybody should be
Yes,
able to
sir.
hear it, to see and hear it.
Mhm.
Let's see if we can make this happen. Mhm. There we go. Should be DVD drive. There it is. Which one is it? There are three files.
First judge won't hear the sound.
Okay.
So this individual, he told me where Mr. Johnson was when I arrived on scene. Excuse me, sir. Hi, how are you, sir? So as you can see, he turned,
Why don't you
looked
come
at
talk
me
to
and
me for a
acknowledged
second?
me and walked away.
Sir,
I'm talking to you.
It's spinning. Wow. Didn't like that. Let's try again. Okay, let's take out the disc and try it again.
I shouldn't have done
Mm-mm.
that. Okay.
Let it load. Let's see if we can. See, it's not recognizing the drive now. There it is.
Didn't see it or anything. Okay.
Just see him start on.
No.
Do you want Mr. Crawford to sign a return notice, or are you going to serve him with the compliance? When he helps him?
I think we'll just serve with all of them at the same time.
Yes, sir.
It'll just be better for him. It keeps freezing.
My name is Bill.
Is that the name?
Let's see here. Where did it stop?
Sir,
Right.
hey, I'm talking to you. Sir. Hey, talk to me for a second. Talk to me for a second, okay? What's going on here?
What's going on here?
Yeah.
I don't know what's going on here.
You have your ID on you?
Do I have an ID on me?
Yeah.
Sure.
Can I see it?
Well, I mean, you have to have an ID to vote?
Oh, yeah?
You do?
Hmm?
Have an
I
ID
just-
to vote?
Can I see your ID, please?
Yeah, I got an ID.
Okay, I just wanna know who I'm talking to, you know? Why don't we come
We're
over here?
talking to Bill.
Why don't we come over here and talk so these people can leave the restaurant, okay?
Well, I'm just talking to Bill.
I know, come over here and talk to me in the grass over here, okay? Watch out. Come over here for me.
So I attempted to get him
Come over
in
here.
the grass, but
You have your ID?
insisted on standing
Right
right
here.
there.
In the grass.
Which ID?
Your ID, like your driver's license.
You don't have an ID to vote.
Huh?
You don't have an ID to vote.
I have to see your ID though. I want to know who I'm talking to.
What, I gotta have an ID to walk?
No, you need an ID.
But you
because-
have to get what you.
Hey, hey,
Listen,
calm down, calm
You
down.
don't have
Sir,
to have an
sir,
ID to vote.
Sir, calm down.
I'm not coming down.
You're not?
Who has to have an ID to vote?
I need to see your ID. Can I see your ID?
You don't need an ID.
I do need to see your ID.
No, you don't.
Okay, well, what's your name?
My name is Bill.
Bill, is that the name on your license?
My name is Bill.
Is that the name on your driver's
I'm
license?
just like all these fuckers that come
Hey,
across the
hey,
border.
hey, hey,
They don't
hey,
have an ID.
hey, 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 do me a favor. calm down for me, okay? I'm just trying to talk to you here. Okay? I'm just trying to talk to you. I just want to know who I'm talking to, okay? What's your last?
No, Teddy, there's my problem.
Hey,
I don't have an
hey,
ID.
hey, relax.
I don't have an ID.
Hey,
All these motherfuckers run across the
listen,
border.
listen.
Don't have
listen
an
to
ID
me,
either.
Listen to me, listen to
What's
me.
my
I
problem?
need you to calm down.
I'm American
Okay,
citizen.
okay. And I believe you. I believe you're an American citizen.
So why you ask for a fucking ID?
Because I want to know.
Don't
who
you
I'm
go
talking
down
to.
to the border
Hey,
and ask them for a fucking
that's
ID?
not my job.
No, they run across the fucking
that's
border.
not my job.
They run across the border.
That's not my job.
Oh, I mean, you asked me for ID.
I
up
know,
here.
because I got
I'm
cars
here
out
in
here.
Kennesaw,
Hey,
I'm up here in
Hey,
Kennesaw,
hey.
So at this point in
You
time,
asked
he
me
was
for a
yelling
fucking
to
ID.
the point
Calm
where you
down.
could probably hear
Kennesaw,
him
Georgia.
the entire
Down.
parking lot.
calm down. I'm trying to talk to you.
What's the difference?
Hey, I'm trying
I'm
to.
in Kennesaw, Georgia.
Okay.
You asked me for a fucking ID up there.
Yes.
Why don't you ask you motherfuckers for the ID when they cross the border
'Cause that's
in
not my job.
Texas?
Because that's not my job.
Because I mean, obviously I'm white.
Okay.
So you're trying to arrest me here in Kennesaw.
When did I say
You
I
don't have
arrested
fucking
you?
ID. But them bastards
When did I say I
come
was
over
arresting you?
there,
When
the
did-
Rio
when did I-
Grande,
When did I say I was
and
arresting you?
they don't have an ID.
When did
You
I?
here,
when did
ask
I
me a
say I was
fucking
arresting you?
ID. You asked me an ID in
Dude.
Kennesaw, Georgia.
I'm just trying to talk to you.
You asked me for an ID in Kennesaw, Georgia.
$11:49. Take care. You're under arrest for public intoxication. Please do not move. Do you have anything on you that is very important? I didn't break it, so watch out. You might not.
Yes, you. Yep.
That's good.
Okay.
Yes. Which one's your car, sir?
Over there.
Well, I see it when you.
Yes, we are gonna ride in my car, but which car is yours? Which car is yours?
I'll ride this far. That's what you told me.
Yes, that is true.
Excuse me, sir.
Which one is yours?
Is that his white pickup over there?
Yes, ma'am.
Okay.
There's a lot of white people in Texas. Here, yeah.
I know which one I'm talking about, though, and he does too.
Yeah.
Okay.
Well, yeah, put that on the media right now.
No, you're already being
Your own
recorded.
business is? Oh, okay, you're gonna arrest me?
Yes, sir, you're under arrest.
You arrest me for respect my political beliefs? I think it's because you don't respect my political beliefs.
Okay.
Know your political beliefs.
I just walked out of Hooters.
Yes.
And you arrest me because I walked out of Hooters.
No.
Because I'm intoxicated.
That would.
Yeah, you did. You arrested
Hey,
me
look over here.
because I walked out of Hooters.
Indeed.
Intoxicated.
You're right, man. You're right.
No. Nobody can ever come to Hooters. Because if you walk out of Hooters, somebody's gonna arrest your ass because public intoxication. Don't run with my balls too closely.
I don't want
I
to.
don't like that.
That was
I
your.
think you're a
right.
gay motherfucker is what I said.
Okay.
Get run with my balls
No.
too close.
Taking the money.
I don't like it. I don't like it at all.
I don't want to touch your balls at all.
You didn't touch my balls. Obviously, you love my balls. You run around my balls very closely. I mean,
The Hooters girls can hear you. Can you keep it down so they don't think you're making?
well, I think you're gay.
Okay.
I think you're very fucking gay. You're running around my balls too long.
I didn't touch your balls.
You're dead rubbing my fucking balls.
Okay.
You're dead, motherfucker.
All right.
I think you are.
Okay. Call me names all you want, man. Don't bother me.
Whatever. I'll stand here.
Yes, you are.
I never did anything wrong.
Okay, what's your last name, sir?
Last name.
Yes, sir. What is your last name?
Last name.
Yes, what is your name?
Why gave you my last name?
You never
What the
gave me
fuck
any.
did I do wrong?
I already explained to you.
Pumpkin intoxication?
Yes, sir.
I walked out of fucking Hooters. I walked out of Hooters. It's pumpkin intoxication. I don't think I did anything wrong.
Right.
This is a fucking establishment that sells beers. I walked out of here. I don't think I did anything wrong. Nothing wrong. Okay. I walked out of here. You tell me I'm publicly intoxicated. Did I walk out of a fucking bar? No. You told me I'm pumpkin intoxicated.
What?
You know, is there not a bar here?
What?
Sir,
I believe there's a bar right here right now.
Okay.
can we walk that way?
There's a bar right here right now. So you gonna arrest me right outside the fucking bar?
I'm not gonna listen to you.
Okay.
I walked outside the fucking bar. You'll arrest me from public intoxication. You walk by inside a Hooters bar.
Hey, do me a favor.
No, I'm not gonna say shit. What I'm telling you, I walked out of fucking Hooters. I walked right outside Hooters. You'll arrest me for public intoxication. You gonna arrest me for public intoxication?
Sir.
Cause I walked outside Hooters. I walked outside Hooters. And you arrest me from public intoxication. I walked outside of Hooters. And you arrest me from public intoxication.
Yes, sir.
I walked outside of Hooters. And you arrested me
Straight to your
from
left.
public
Straight to your left.
intoxication. Yes, sir, I can. No. I'm sorry, we don't need this.
It's too late now.
No, we don't need this.
I'm
Mark.
not asking you.
No, I'm not saying, I'm not gonna resist.
Okay, then
I
just
don't resist.
Okay.
Please let me
Can
go
you
in
just have
there.
a seat right there?
Yes, sir.
Thank you.
Yes, sir. Please let me go in there comfortably.
Go ahead.
Yes, sir. I don't
Go
want to
ahead.
resist against you.
Perfect.
Definitely.
Go ahead, have a seat.
Yes, sir.
All right, thanks, man.
Please. There's not gonna be
Watch
no
your head, okay?
conversation.
Yeah.
There's not gonna be a conversation.
Good.
Just
have a seat,
please,
okay?
please, just let me, yeah. sir.
Yeah, sit straight
Yes, sir.
down. There you go. All right, now sit down to your butts down, just rotate.
Yes, sir.
Okay, I'm going on the other side.
I don't want y'all to go through everything you ever want.
I don't know if y'all right there or not, but my hat's off to her. She was saying some shit, and she kept her cool. So, girl, man, yeah. You want to throw that out? I had your back.
Thank you, I
told you,
appreciate
I
it.
know what he was gonna do.
No, I get you. I appreciate it.
All this shenanigans in his car,
Yep.
except for the
Wallet.
phone. We think he was drinking before he came here. He was fine. He's
Yeah.
And then we were like, whoa, you're done, bud.
Yeah, it didn't seem like he was very aware of what was going on. No. He kept yelling that I needed to know.
Everything. I'm freezing. Can I go inside? Y'all
Please
come-
do.
Yeah, you're good. Thank you, sir. I appreciate it.
I appreciate y'all's help tonight. Going.
Thank you, sir. Yeah, he said his name was Bill and that I didn't need to see an ID because he's not going across the border. And I said, well, that's not my job. I'm just trying to figure out who I'm talking to. Uh-huh. I pulled up and he was yelling and then tried to walk away. All these changes going on here.
Good job.
Did that? Yeah. Yeah.
Don't be
Yeah.
afraid to be like, "Nah, you can get this on your own."
Yeah. It was like,
Cause I am already.
it was like, ooh.
You notice the movie sign is always color 6x6.
Yep. Mm-hmm.
But on this case,
Yeah. Give me a look and see. Oh, hello. Hello.
and his kids Maria.
Oh. Yep.
Get outside of a bar.
See how gross it is?
No. it's-
Oh, uh-huh.
Not in uniform, it's harder to,
Yeah,
because a lot of them stay away.
yeah. Oh, yeah. You pregame. You want me in there and talk to him?
Yes, what he wants.
Okay.
Don't push the issue for a
Yeah, no. I know.
He's like CT, yeah.
Okay, cool. Okay, I just wanted to see if you wanted anything out of this or are you good with?
Come back. I don't want him here anymore.
Okay, so you would like to have him CT'd or no?
Yeah. I
Yeah.
don't want him here anymore.
Okay, I gotta go get some paperwork that I need you to fill out and then we'll go from there, okay?
Okay.
Just stare. I'll just come to the door. Okay. Yeah. Yeah, you want some CT, so okay, you got it. I'm gonna just have him fill out his part, and if you want to fill out the rest.
Yeah, you already, can you just run him real quick?
Yeah, that's what I was gonna do.
Local. Okay, man, you can tell your lawyer, okay?
I saw it.
Yeah, I was just gonna have him sign his part
Okay,
or
bud,
whatever.
you can tell your lawyer. Okay.
I was just gonna have him sign his part or whatever, and then just give it to you and run him and everything. Yes. You have the address of this place. Need that, right? Just his signature and his name?
Correct.
Okay. Okay, sir. So all this is gonna be filled out, but basically I just need your signature right here where it says print name and signature. And then, so authorized representative, just print your name. Yes. And then right here, put your name right here. Authorized by.
You want my legal name or I go by Matt?
Yeah, can I get your legal name on there? And then do you have your ID on you?
Yes, ma'am.
I just need it for like the report, just saying like, hey, we spoke to him and he, you know. So sorry this happened.
It's not your fault. So he was fine with serving him beer too.
Uh-huh.
He stood up to go to the bathroom like, man, he had to have been, he could barely walk.
Dang.
He goes to sit down over there, he fell out of his chair, we helped him up.
Yeah.
And he takes off to the door and I was, dude, I can't let you drive.
Good
Let me
God.
buy you a taxi, let me buy you a taxi.
Yeah.
So
No, you're fine.
he's like, no, I'm driving home. I was, dude, I'm buying you a taxi.
Yeah.
So you can walk, but you cannot drive. As you see.
Yeah. 153. Can you copy 1027? Zero 50-631-078.
Oh, him tonight.
Hey, we just take him there and drop him off. Good birthday gift. There you go. And so he'll get this whenever he gets to the jail. He'll have it. If he comes back here, then you just call us. Yeah. Yep. Thank you, sir. I appreciate it.
Over and over again. When my partner showed up, I screamed at her over and over.
person wants to storm. Yeah, so he's just gonna be held in the jail overnight and he'll be released, okay? Okay. Yeah, is he in Alcoholics Anonymous or anything? Okay, well, he's had way too much to drink tonight.
Let them know I'm about to pull out so they don't mess up their chair.
No, they're fine. They're parking, I believe.
All right, so we're gonna take him to the Ackworth jail right now, okay? I locked it, it's in the parking lot here. Yeah, he can't go get it because he's being told he can't come back here. But yeah, you can come and get it.
It's a bunch of horse shit.
You be
It's
as
a
mad,
bunch of fucking horse shit.
be as mad at me as you want.
Yeah, I'm a fucking mad at you. You're a goddamn son of a bitch.
Okay.
You're a fucking son of a bitch.
Pardon?
Wasting your fucking money. You're trying to
He
fucking
has them at the jail.
around a fucking street. Once you go down,
Yeah, I'll take it.
I walk out there.
Where
this fucking
about do you live?
public, this, you know, my shit out there for you. Right there, dude.
And
It's a target.
can you say that one
It's a
more time?
fucking
I can't hear
target.
you. It's freaking out.
That's okay, motherfucker. That's what you get your shit done.
Yeah,
I'm a fucking veteran.
sure. I will send you the jail
You
address.
horse shit.
Is
You horse shit.
excellent.
All these fucking liberal motherfuckers around you.
Yes, ma'am.
Tell you something. You're a fucking horse.
Need anything
My
else
good
from me?
man, I am not a liberal motherfucker, but I appreciate the offer.
You're a good man from spend a night.
But what
in
I
fucking jail.
happen to let you
Or
know,
get beat. Horse shit.
the way that you are,
That's a fucking horse.
the way that you are screaming is not.
You need me for anything else?
Hey,
guy. Don't drink too much, okay?
Mhm.
Okay.
Yeah. Have a good night. Drive safe. Yes, sir. I believe the video speaks for itself. I'm not exactly sure what else I could add to it that I haven't already. Yes, sir, I do. Yes, sir, I do. Yes, sir, it happened in the city limits. Yes, sir, it happened. in the jail.
Okay, do we want to, is there anything else for the video now, or do we need to bring the lights back up? I can turn it off. All right. On the next one. All right, then we'll just wait for that. In the meantime, we'll go back here. If we can bring the lights back up, that'd be great. I don't know what button to press. There we go. All right, so is it direct finished? Is your direct of this witness? Okay, cross. Sure.
Just very few questions. That Hooters, to your knowledge, that Hooters operated or owned by the city of Kennesaw?
I'm not exactly sure if it's owned by the city of Kennesaw or
Any
by someone
evidence
else.
that you're aware of, that it's owned by the city of Kennesaw or operated by the city of Kennesaw?
No, sir.
The land it's on, do you have any evidence or any personal knowledge that that land is controlled by the city of Kennesaw?
No, sir.
What about the county of Cobb? Do you have any knowledge or information whatsoever that Hooters restaurant is owned, operated, or controlled by Cobb County?
I do not.
What about the state of Georgia or the United States of America? Any information that you know of to suggest that location where Mr. Johnson was at was controlled, owned, or operated by the state of Georgia or the United States of America?
Not that I know of.
And I assume the answer would be the same if I was to ask you if it was owned, operated, or controlled by any subdivision of any of those entities.
Yes, sir, it would be the same.
With regard to making an arrest for intoxication under this statute, how intoxicated does a person have to be?
It depends on basically the entire circumstance. It depends on the way he's acting, the odor of alcohol and everything like that. It doesn't say specific limit as to how intoxicated he has to be. But when we arrive on scene, we look at the totality of the circumstances to make our judgment.
So someone could, so basically it's up to the officer to make the determination. Is that fair?
Mhm.
The officer makes a determination whether or not the person's had too much.
Yes, sir.
And there's no standard expressed anywhere in statute. Are we agreement on that?
Yes, sir.
All right, can this witness be excused?
Yes.
All right, you're released from your subpoena. Thank you for being here. We appreciate it. That'd be great.
I swear. I'm Officer Chris Johnson. I work for the City of Kennesaw Police. I started policing for the City of Kennesaw in April of 2019. Before that, I worked as a patrolman for the City of Decatur for about 3 years. Before that, I worked for Rockdale County Sheriff's Office as a patrol deputy for about 3 years. Before that, I was a military policeman in the United States Marine Corps for about 8 years. They do. I was. Yes. Yes, he's sitting to my left wearing a baby blue shirt and a dark blue blazer. Hooters Restaurant, which is at the intersection of North Roberts Road and Old Highway 41 at the same juncture where it meets Cobb Parkway, which is US 41. It was actually outside in the parking lot. Yes. Yes. So I was actually dispatched primarily to this call. I was across town. I think I was getting food. I don't remember exactly, but Officer Owens responded as my backup officer, and she responded first, which hate it when they beat you to your call, but she did. So as I pulled up, I was either on Cobb Parkway or on Old 41, and I could actually see the defendant standing, looked like his hands were in fists, and I could see one of his hands like pointing forward and back directly at Officer Owens. I could tell his neck was bulging. It looked like he was screaming, and he looked like bowed out, like trying to make himself look bigger in front of Officer Owens. I called myself arrive on scene. Immediately, as soon as I saw him, I started walking quickly toward Officer Owens. I thought she was going to get hit by the way that he was moving. I could smell him from probably 15 feet away, and immediately just placed him into handcuffs. After that, there was quite a tirade. We searched him incident to arrest, returned his valuables to his vehicle, and then did some just investigation about what happened. I don't know when it came through, but I know that it was known to officers that, first of all, if we get called to Hooters, like to remove someone, they almost never call us. So it has to be a pretty serious occasion. So we go in, I start talking to the manager. I forget his name. I think it's Matt. And he says, like, listen, this guy kept going to and from the bathroom.
Yeah, it is hearsay. So hearsay is an out-of-court statement that's offered to prove the truth or veracity of that statement. It would only be admissible under certain exceptions or if the actual speaker is present in court. So be cautious of that. That is hearsay, so it can't be admissible into evidence what someone else said that's not here.
Okay. So while speaking with the defendant, he just reeked of alcohol. He shouted constantly profanity. I mean, I don't think Hooters is a family restaurant. However, I could see children walking in and out of the restaurant. I could see adults walking in and out of the restaurant, younger folks, older folks, like everywhere. There's members of there's citizens of the public, just everywhere. There was no privacy or expectation of privacy anywhere around us. Simply with public intoxication under the city ordinance, I was trying to actually make it easier on him. I didn't want to go forward with disorderly conduct because that would have been a state charge. I believe it's 6-107. Yes, that's correct. I did. Yes. That's correct.
It says he's intoxicated. In your training, as a police officer, have that in regards to intoxication?
I have. My first formal training considering intoxicated people was in 2004 with Colonel Bill Kavanaugh's DUI enforcement. That was at Laguna Hills, California PD. After that, I subsequently have attended standardized field sobriety testing as well as advanced roadside impairment and detection, also known as A-RIDE. Gotten several. I don't know how many DUIs I've successfully enforced, but it's well into the hundreds. Not to mention, I've attended several Marine Corps balls and seen plenty of intoxicated people. Yes, so sometimes when people drink, they smell heavily of alcohol. In this case, the defendant did. Sometimes they tend to turn up the volume on their voice. In this case, the defendant did. They tend to not hold back in their opinions, not able to follow rational discussion back and forth. And they tend to pull things like, well, what about this? What about that? Like, nobody's talking about those elements. Like, we were talking about something very simple, and this is confined what the argument is. Like, this is what the discussion is about, and tend to pull from outside of that argument. As it relates to the defendant, he displayed all of the signs of someone who's loud, opprobrious, heavily intoxicated, boisterous, smelling of alcohol. I mean, when I tell you his face was ruddy, it was very red. His neck was swollen with how much he was shouting. And he did display, something happens whenever people get heavily intoxicated where they have trouble discerning different motor functions. So if they start to scream, their hands will ball into fists. Right? Like the body is undergoing stress and it doesn't know how to dissipate the stress. So it does it throughout the entire body. So that was, again, what it looked like. I did. So as he would shout, his elbows would go back, his hands would get deeper into fists. Yes. Yes. So central nervous system depressants also depress the body's ability to discern one system from another. So it is likely that he was struggling to, if his body is shouting, it is also physically looks like it is shouting. He can't just shout and relax his body. Does that make sense? So there are things that happen in the body physiologically when under the influence of several different substances, but primarily central nervous system depressants that cause you to display effects that you cannot separate the effects on your body. So like you'll see people's faces get flushed, right? That's some of the effects of alcohol. I did. I believe it's all on the same disc as Officer Owens. I don't know. There's two discs. One has the some body camera footage. The other has the in-car vehicle footage.
We want to keep the same one. Who's the other one?
I think this is the L3. That's the right case. That looks like the in-car camera. So
This one says body cam.
Yeah, we can
that's
just
the
go
body
ahead
camera footage.
and get these going. All right, so which one do we want to look at?
Yes, not the
Purple one.
it's the other one. I'm sorry, can you say it again? Yes, sir. Does that say DVR 5866? That's the vehicle footage. I mean, it's all relevant footage. It's just this only shows me pulling up and then after I return to the vehicle. It would make sense for a timeline of the case.
Right.
I think we see like it's gonna show essentially the same thing that the other one's trying to. I think the speed limit is kind of hard. Yes, late in the afternoon, but we speak like that they're gonna show about the same thing. Officer.
Okay.
On video.
I mean, the only thing that's going to show differently is as my view when I'm approaching Officer Owens and defendant. That's, I mean, it's, yeah, so that's essentially, it's a similar view. It's not going to be that different. Yes, sir, I did. Yes, sir. Yes. Everything pointed to intoxicated. Yes, sir. I mean, I would just ask like, no, there's nothing I would like to say.
Cross.
Officer, would you agree with me that could, well, do you have any information or evidence whatsoever that Hooters is controlled by, operated by, or owned by the city of Kennesaw, county of Cobb, state of Georgia, or the United States?
Controlled by under the sense that they are operating it? No, they are issued licenses under the city.
Does the city control or manage the operations of that restaurant?
No.
It's subject to the same laws as any other establishment.
Yes.
But the city doesn't have interest, correct? You're not.
No, not that I know of.
You would agree with me, though, that that is a building which the public has is permitted to have access, right?
Yes. Can I ask, though, we're talking about the parking lot, right? Which is almost where almost everything in this occurred, right? Okay.
Officer Owens testified that it was up to the officer to make a determination whether someone was intoxicated enough to be charged under the statute. You agree with that?
Yes.
the statute does not contain any particular level of intoxication that is illegal.
That's correct.
And even consuming one beer results in some level of intoxication, right?
So levels of intoxication can be resulting from one alcoholic beverage, but that's not what most of the data suggests on anybody over the age of 21. It also depends on body fat composition, last meal eaten, tolerance of alcohol. I mean, there's numerous factors. So it's not, I don't know that it's fair to say like, oh, just one beer could cause intoxication or couldn't. It's so many other factors.
And there's no particular level that's legal or illegal pursuant to the statute, right?
Correct.
And the testimony is that the officer has to make that determination whether or not the person is legally intoxicated or illegal.
Right. So I believe Officer Owens was saying that it's up to the officer's discretion if the person gets cited under public intoxication. I would just hold it. I'm saying that yes, but I don't have a mechanical application for intoxication. I have to take the totality of the circumstances, which I believe also is what Officer Owens was saying, that it depends on multiple factors and circumstance. Yes, sir.
Any redirect?
No.
Can this witness be excused?
Yes.
All right.
Thank you.
You're released from your subpoena. Thank you for being here. Go ahead and call your next witness. Okay. That's all right. Does the city rest? Okay. Call your first witness. Sure.
So we're gonna report to the record that word of acquittal in this case. We don't believe that the state has carried its burden. As I pointed out during opening, Your Honor, the statutory scheme, it's all about the statutory scheme. I saw the video. I understand why the officers don't like it. I understand why the prosecutor doesn't like it. I understand why you and I don't like it, Your Honor, but it is what it is. And the statute says what it says. And there are defined terms in there that make it impossible for the state to meet the burden in this case. And the evidence only supported that. OCGA section 6-107 specifically states it shall be unlawful for any person to be on public property within the city while intoxicated. Public property is not defined in section 6-1. So we look at section 1-2. The preamble to section 1-2 states, in the construction of this code, in all ordinances of the city, the following definition and rules of construction shall be observed, unless it shall be otherwise expressly provided in any section or ordinance, or unless inconsistent with the manifest intent of the mayor or council, or unless the context clearly requires otherwise. In this case, there are specific definitions, and there's two definitions that are important. One is public property, and one is public place. Public property means any land or lands controlled by, operated by, or owned by the city, any county of this state, any municipality of the state, the United States of America, or any subdivision of any of them. Under that definition, Your Honor, it is illegal to be intoxicated on public property. It's illegal to be intoxicated on school grounds. It's illegal to be intoxicated at City Hall. It is not illegal to be intoxicated in the parking lot of Hooters. A Hooters is a public place, and the officers testified that it met the definition of public place. Your Honor. A public place is defined as any building or conveyance to which the public has or is permitted to have access, including restaurants. It could not be more specific. I didn't draft the statute. The officers who made the arrest didn't draft the statute. They thought they were charging a correct charge. The officer testified, and I don't doubt it, that the officer was trying to be lenient. Be that as it may, Your Honor, we only have the charge, and Your Honor can only consider the actual charge in the words of that charge. And under the law charge, Mr. Johnson is not guilty of the state, not met its burden of proof. There is no manifest intent that is different in the statute. And it cannot reasonably argue when there's a definition as to which Hooters specifically means that it should meet some other definition.
And so we believe on that grounds, the court is required to grant a verdict of acquittal. But the court may not like the video, I understand all that. But I mean, all we have is the statute. And this court should uphold the law as written and as charged. With regard to the second issue raised, Your Honor, we believe that the statute is inherently unconstitutional because it allows complete discretion with the officer to determine whether or not the person in question has violated the statute. And that was the testimony that's given, Your Honor. And that's the difference between a DUI statute, driving under the influence statute, and this statute. A simple intoxication statute that leaves it up to the discretion of the officer to determine whether it's been violated or not violated is constitutionally problematic. Thank you. I will try to be definite. Members of the public need to know whether or not they have violated the statute. It is not enough to say, hey, I saw that video. Anyone should know that that guy's intoxicated. That's not the point. The question is the statutory scheme valid? The statutory scheme is invalid because it's imprecise and arbitrary. And the court can't uphold an arbitrary statute. Even the court says, yeah, but I know that guy was intoxicated in this case. That doesn't make the statute valid. The statute has to be definite. It has to be understandable by a member of the public. You have to know whether you've had 2 beers, 3 beers, 4 beers in Hooters, whether it's okay to walk out. Now you can tell that with regard to driving a car because there is a test. And they'll test your blood alcohol, and you can know with precision whether you have violated the law or not. But it's not up to the officer to make that determination. It's up to the evidence. And so we believe that, number one, under the plain version statute, burden has been met, but we also believe the statute is unconstitutional.
Response.
Your Honor, I disagree from that. Your Honor, the code section is clear. It says if the public intoxicated, then the officer will turn around and down from the street. Walk on any person to be on public property. One thing that we want to talk about as far as public property is concerned is that the reality is public property is like a restaurant that invites people to come into their restaurant. It is public. It is public property because people are allowed to come in and congregate in the location. And as a result of that, this person was there in the parking lot, and it was unlawful to be on the public property, and that is public. Because the public is invited to that location within the city limits while intoxicated. The city limits, of course, the city of Kennesaw is approved in regards to that. Your Honor, there's a number of things that we oftentimes get charged in other people's places, like in restaurants and things of that nature, where you have to come into their place because they've invited the public. And that is what they're referring to as far as public property. The public is there, and in this particular case, the officer has absolutely the right to come in and to arrest somebody that has been charged with being intoxicated.
I would just, but very briefly, Your Honor, that is the absolute definition of public place. That is not the word in the statute. It's a very easy fix for the city council. You need to substitute the word public place, public property, if that's the intent. But what council just described is the absolute definition. You could have been reading for it. It's a place, a public place, not public property. A public place is a place the public has or is permitted to have access. And there's a distinction in statute between a public place and public property. And it's just that simple.
I appreciate both arguments. At this time, I'm going to deny the motion for a directed verdict. Go ahead with the case. Okay, so defense rests. Closing.
Your Honor, obviously, looking at the video, they intended act to my officers, to individuals around them. I feel obviously we carried our burden of proof. The officer trained in their training they use for the purpose of determining the person under the officer's weight. I wanted to also, Your Honor, asking the court, charge of $1,000 for surcharge, but also I asked the inmates jail, sort of, charge, to be on probation for a full 6 months, and to be obtained same use of alcohol and drugs, use evaluation as directed, and follow all further directives, treatment and counseling. Also abstain from the use of alcohol and drugs, be subject to random alcohol and drug testing and blood, breath, urine, and hair, as requested by court, probation, and law enforcement. Also would ask the defendant to attend 6 anger management sessions for the process. Thank you.
Respectfully, Your Honor, there may have been chargeable conduct, but it wasn't charged under the statute that applies in this case. Court's familiar with the argument on that issue. If the court disregards the statutory scheme and convicts my client, Your Honor, we disagree with the sentencing recommendation. We believe that it is excessive. Certainly, the behavior witnessed on the video is appropriate, but we don't believe that jail time is required other than the night it's already, the jail time is already served. And we certainly don't believe that 6 months probation would be appropriate in this case. We believe that the court should dismiss and quit on these charges.
All right. I appreciate the evidence and testimony that's been given. I am going to take a 10-minute recess because I want to review the statutory language that everyone has indicated. I've been looking at it briefly as I've been up here, but I want to spend a few minutes with it. And I'll reach a decision and come back. So we'll be in recess for 10 minutes. I have it.
I'm sorry. This is showing 1 hour. Really, for public inbox? Oh, okay. All right, so it's, okay, thank you. Hey, Matt. Hey, Kat. Hey, Kat. Are you getting?
After review of the evidence presented at trial, the testimony of all witnesses for the city and for the defendant, and review of the law and the precedent legal cases of both parties, I hereby find as follows. On sole count of public intoxication in violation of 6-107, I find that the city has not carried its burden of proof in that case due to the language of the ordinance, which indicates public property. There is no definition of public property in Chapter 6. When there is no definition, you default to the definitions in the Chapter 1 of the ordinances. The definition of public property in Chapter 1 is publicly owned, is governmentally owned and operated property. The parking lot of Hooters, although a public place, is not public property under that definition. However, your behavior to those police officers and those persons in that parking lot was the most reprehensible thing I believe I have ever seen. You should be so ashamed of yourself and your behavior. I'm glad you got to see that. I hope it burned an image into your head. You're getting out from walking out of here today. But if you engage in behavior like that again, it will not turn out so well. This was a technical issue where an officer charged the wrong statute. It does not mean you did not do wrong. I am so disappointed that you wear an American flag and parade around as patriotic. I see this, yet you behave in this manner to our law enforcement officers who are serving and protecting our community. It's an embarrassment. Now, I say that first, and I'll say this second. You were drunk. There's no doubt about it. It's not an issue. I can make a finding if that is necessary, but you were drunk. If you need help, get help. I know that you have a history of this. This isn't the first time, but it needs to be the last. If you won't get help, it's going to continue to get worse. If you want help, members of this court and me personally, I will do anything I can to help you get help if you want it. If you're ready to make a change, you can make a change. And today can be the first day of the rest of your life moving in a different direction. But it's your choice, and you have to make that choice. You have to think about your priorities. What's important to you? Do you want your family and friends to see that or not? That is something you've got to decide. Now, that's the order of the court. I wish you good luck. Mr. Day. Can I see you in chambers? Yes. Officers, thank you so much for your time and efforts. I can't tell you how much we appreciate you.
Got you in jail cases. I think this is Randall's file because I think it's Randall's file. Yes. Unless we're doing jail cases. But that doesn't concern you.
Somebody knows what chair stays in their office and which one's don't.
This goes. You have to put the printer on it.
Hold the one out that's in there now. There's one,
What kind? Just one of these?
yeah, it's a black one with arms.
Like this? Yeah, that comes out. Oh, it's
Back out.